Hi guys, it's Tracey from Cape Town, etc. And I'm sitting here again with Kelly Phelps from UCT, who's a lecturer in criminal law. And today we're going to give you some insight into what we can expect to see at the sentencing hearing. He was convicted of premeditated murder in the first 3 counts, not just murder. And with premeditated murder, we have a prescribed minimum sentence of life imprisonment, which effectively means that he's not going to be eligible for parole before serving 25 years. And then, in fact, he'll be paroled for the rest of his life. So what are your thoughts on whether or not Judge Desai will sentence him with life?
There's a few things that are generally misunderstood by people about a sentencing phase in a criminal trial. So the first thing is that the sentencing phase is actually its own small trial. The parties actually need to prepare afresh to present evidence that is particularly relevant for the sentencing stage. So now it doesn't become about a standard definition, it becomes much more about this particular accused person and their personal circumstances and the specific circumstances of their particular criminal conduct. And for that, new evidence needs to be presented, and both sides will present that evidence. It's not actually a mandatory life sentence, which means it's automatically imposed for premeditated murder. Premeditated murder triggers the operation of the Mandatory Minimum Sentencing Act, and the specific section says that for premeditated murder, the standard sentence, the usual sentence, should be life imprisonment. However, there's another section of the Act that says unless there are substantial and compelling circumstances, and it's that question that the sentencing trial will revolve around. The state will be putting evidence on the record to suggest that there are no substantial and compelling circumstances, and in fact, the life sentence should be imposed. And the defense will be trying to put evidence of his personal circumstances to suggest that there are substantial and compelling circumstances and a lesser sentence should be imposed. There's more than one count here.
Yes,
so we could have multiple life sentences, and then there's options of whether they get imposed concurrently or consecutively. It's certainly going to be a heavy sentence, we know that.
There's 3 premeditated murder convictions. You know, the default is that there should be 3 life sentences, and that doesn't even include what the sentence might be for the attempted murder as well as the obstruction of justice. So I think the defense is going to have an incredibly difficult task to try and show substantial and compelling circumstances in a case where there are 3 premeditated murders.
The other thing we should mention here, of course, is that the sentencing trial could also impact the issue of appeal, because an accused person can appeal on the basis of their conviction, but they can also appeal just on the basis of their sentence. So if Henry's team feel that the sentence ends up being unduly harsh, they could also launch an appeal just on the basis of sentence.
So at the sentencing, what we can expect from the state to argue is things like the consequences for the victims of his crime, as well as the seriousness of these crimes and the fact that there were multiple crimes. And then also the state has to argue that the interests of society need to be protected and considered here. That really is pivotal to our justice system. But what sorts of examples do defense teams normally raise in sentencing hearings like this?
And one of the interesting factors actually is this issue of the interests of society. Most people automatically assume that falls into the state's argument alone. But in fact, that very often comes up in the defense case also, because the concept of the interests of society is quite a broad concept. And in that concept, factors like an accused's prospects for rehabilitation would be raised, because the argument would be that it's in the interests of society generally that accused persons are rehabilitated and that they don't get released after prison to reoffend, but in fact are put in circumstances that make their rehabilitation optimal. Another issue that's come up in many cases in the past has been an accused's youthfulness, that they have their whole lives in front of them, and the implication of that argument is that when someone is still youthful, they are more malleable, their character is more malleable, their maturity is still happening, and therefore they would be more receptive to successful rehabilitation. There's also the issue of prior offences. If this is a person's first offence, that will often get raised as a factor. And then, of course, the main focus for any defense team would be the personal circumstances of the accused. So, for example, in this case, we know that the accused has been diagnosed with epilepsy. So those are the sort of gamut of things that are very commonly used in these sorts of cases.
Yeah, so I suppose in this case where Henri is 23 years old, so he is very young, and to impose a life sentence, which means he will serve 25 years in jail without being eligible for parole, despite the fact that he might have been rehabilitated sooner than 25 years, would be exceptionally harsh.
They have to decide, would that be a harsh outcome? So the principle that guides a court in sentencing is the principle of proportionality. So a court needs to ensure that whatever sentence is attached to a particular crime, it is proportional with the seriousness of the crime that was committed, and is this a fair, just, and equitable sentence. And that is essentially the court's aim in issuing that sentence. Can they deliver a proportional sentence? And they may feel that because of the particular heinousness of this crime, that it would indeed be proportional to have a life sentence or even multiple life sentences.
So at court on Monday, we actually got some insight into what documents will be produced at the sentence hearing. It was used to justify a postponement for 2 weeks, where Advocate Breda said that he needed 2 weeks to get a NICRO report. What is your knowledge of that sort of report?
It's very common in a sentencing trial to get a report, and they are most commonly produced by NICRO, in fact, which is one of the longest standing NGOs dealing with criminal conduct, crime behavior and criminal reintegration. And they will produce a lengthy report, usually, detailing all of the offenders' personal circumstances and their propensity for rehabilitation and later reintegration into society.
I mean, I understand why the defense would request such a report, but it seems that given that it is an independent organization, that they also are taking a lot of risk, that the recommendation may not be in Henri's favor.
Equally, you can't persuade a court without tendering any evidence on which to base those persuasive arguments. So they have to seek these sorts of referrals, and NICRO is absolutely the right organization to go to, because this is precisely what they specialize in.
Regardless of what this report produces, even if it is negative to Henri's position in the sentencing, they will have to show the court this report.
I mean, it would be very difficult for them at this point not to, because as you mentioned, Advocate Breda actually mentioned in court at the conclusion of the verdict that they were setting up this evaluation with NICRO. So it would certainly look quite negative for them in the eyes of the judge if then after the 2-week postponement they don't indeed produce a report.
Henri was sent to Pollsmoor Prison, and it was a direction from the judge that he would go to Pollsmoor Prison. Would the judge decide what prison he goes to?
In our area where this case has happened, yes, most of the cases will get sent to Pollsmoor, unless there is terrible overcrowding issues, or unless there are very particular circumstances of an accused person that makes it completely unviable for them to be sent to Pollsmoor. So, for example, if they had a very specific disability that could simply not be catered for at Pollsmoor, then they may have put in an application specifically to be sent to one of the other prisons. Of course, when you're looking for maximum security prisons, because he would obviously have to go to a maximum prison. Yeah.
I did get a lot of questions from Twitter regarding the facility that is Pollsmoor, and especially from international audience who don't really understand or appreciate the consequences of being sent to Pollsmoor Prison. And I know that we were chatting before this, and you said that you've been there and you've actually done some work at the prison. So can you enlighten us to the kinds of conditions that you would experience at Pollsmoor?
It is a very bleak place, a very dark place. The circumstances are incredibly harsh. It's one of South Africa's oldest prisons, so it's simply not built or geared for the modern concept of imprisonment. It's very cold, it's very stark, it's incredibly overcrowded. And it really doesn't lend itself to modern concepts like corrections or rehabilitation programs. The prison, like many of our prisons, but Pollsmoor in particular, is rife with prison gangsterism. So it's a very dangerous and violent place to be as well. So yes, I would say for anyone who's suggesting that there is even a way to make Pollsmoor Prison a more palatable experience for a high-profile accused person, I think that's a stretch. They clearly haven't been inside the prison doors before.
So at the moment he is in the hospital wing, and whether or not he will remain there remains unknown. But just to give an idea to our audience as well, what is the hospital wing like?
In the hospital wing at Pollsmoor, overcrowding would be less of a factor. There would be less overcrowding then. That would make it more manageable. Yeah. However, it's not a hospital in the way that most people understand a hospital to be. It's very poorly resourced, and it really just has some nursing supervision. There's not actual proper medical care, and oftentimes because of resource issues around correctional services in the country generally, even access to necessary medication for people's chronic conditions can be quite difficult to get access to. So although because of the overcrowding it's probably preferable to the general section, it's by no means comfortable or anything akin. Some of them have got hospital beds placed in the cells, but yes, it's not hospital facilities, and even the ones with hospital beds, those beds tend to be very old-fashioned, very antiquated forms of hospital beds, and it's by no means comfortable.
So we'll be at the sentencing at the Western Cape High Court on the 5th of June. And you can follow me on Twitter for live tweets from court. And thereafter, we'll get back to you, as we always do, to give you our thoughts on the sentencing.